Premier of KwaZulu-Natal, Sihle Zikalala, has said that he wants the nation to debate whether Parliament should be above the Constitutional Court. In other words, he says that courts should not be able to overrule Parliament and policies passed by Parliament, because that means judges are able to overrule people who are elected to Parliament. You can imagine the reaction this is going to get. It was the Constitutional Court that overruled Parliament in the Nkanda judgment, for example. It's ruled that certain laws are unconstitutional. Zikalala says he's making this call now because the Constitutional Court overturned ministerial regulations around the pre-qualification process for government procurement relating to black economic empowerment in a case that decided primarily on a technical legal basis relating to how the law was drafted. Professor Lawerence Hamilton is a professor in political theory at Wits University. He joins us now. Professor, good afternoon to you, and thank you for your time. This is quite a big comment to make by a sitting Premier. Why do you think Premier Zikalala is making this kind of comment at this particular moment?
Good afternoon, Stephen, and good afternoon to your viewers. To be honest with you, I'm not exactly sure why at this particular moment, but it's interesting that you ask the question the way you do, that it seems such an inflammatory thing to do. From the position of much greater historical purview and theoretical insight, there's nothing odd with the idea of reviewing a constitution. Those things have been defended and done in very many places, in very many times. But I think that if this is simply a manner or a foil through which the likes of Sihle Zikalala and the governing party would like to gain greater power, then of course it's really problematic. But if it's pointing to if it's either pointing to or generates a broader review process, there's no reason in and of itself for that to be a problem. We adopted a certain view of sovereignty, that the Constitution is sovereign, which is very different to what you have in parliamentary systems, where the relationship between the people is sovereign generates the Parliament as sovereign, because the Parliament is where the people's representatives reside. And so sovereignty, ultimate sovereignty, resides in Parliament.
Could you not argue that it still does? Because Parliament could vote to change the Constitution, whereas judges, the Constitutional Court, can't vote to change the Constitution.
Yes, but it's very difficult for Parliament to garner that kind of support. There are various high bars, 2/3 majority, 75% majority for changing the Constitution or various components of the Constitution. And our Constitution, since 1994, our Constitution has been very clear that the Constitution is sovereign. In other words, the laws, the general laws of the land, as articulated in the Constitution, are sovereign. And thus, it follows that any law that's generated as a consequence of our representatives as members of the legislature, the Parliament, creating new laws, those laws can be shot down by constitutional review, as we've seen on a number of occasions. So I'm not talking specifically about anything that Premier Sihle Zikalala was referencing, but in theoretical terms and in historical practice, there is quite a significant difference between a constitutional democracy of the kind we have and what some people call a Westminster-style parliamentary system, where even though you have, in some cases, written constitutions or constitutions by customary law, the sovereign power resides ultimately in Parliament. And sometimes in those sorts of regimes, the Constitution will, through judicial review or other forms, be able to shoot down laws that are created in Parliament. But one thing that Premier Sihle Zikalala does say, which is absolutely correct, is that our form of constitutional democracy, alongside judicial review, does enable the Constitution to act as a very firm bulwark against our sovereign Parliament.
Is it possible to know, I mean, is it even possible to assess which system is better? I realize all societies are different. They have different features. They have different histories. Our history is different too. Westminster systems, for example, there's a reason we didn't choose that system. Maybe that reason changes. Is it possible to say this system leads to these outcomes and this system leads to other outcomes? I mean, in a way, you could look at the American example, become a very litigious society. People go to court all the time. That's starting to happen here, and that's because, like America, our court has immense power.
Yes, I mean that's exactly correct. We are headed in that sort of direction, and it isn't, the problem there isn't just that it becomes a very juridified system. It's that juridification takes away from us as the people the agency and the power and thus the freedom that we ought to have as regards our representatives. In other words, it acts as a sort of disincentive for us to see our parliament as the seat of our sovereign power, even if we can only do so indirectly, right? So the representatives are our indirect means of exercising our agency and power. A system like ours starts to make us, and we've seen this in the way that NGOs and human rights organizations and very many other actors in society do not turn to the sovereign parliament to dispute these matters. They turn first and foremost to the courts. And yes, you can do, and people have done a lot of work on comparing these sorts of systems. And one of the negative outcomes of our kind of system is that you can end up in a very sort of conservative gridlock, where the Constitution acts as a conservative bulwark and gridlock against any change that Parliament is attempting to Parliament, and you would then say the people, ultimately, if your democracy functioned as it ought to, were attempting to bring about. The flip side is that without the secure basis of a constitutional democracy that a clearly written constitution provides, people become very concerned that you're slipping potentially into a situation in which the populace can, as it were, vote themselves out of living in a democracy. But I think that's fear-mongering, frankly. I think there are many examples in Europe, in the Caribbean, not just the UK, where a Westminster model or a parliamentary model doesn't have that sort of outcome. The greatest concern for me, for someone who's concerned with the freedom and power of citizens and our capacity to generate our own laws via our representatives, is that the kind of system we have taken on board, and as you said earlier, there were specific historical reasons for doing that. We effectively undermine our agency by undermining our representatives' agency as political actors. Of course, there are two massive riders there. The first is that if we were to think seriously about changing to a parliamentary system, we would also have to change our electoral system. Because the other thing that has gone with our decisions back in the early 90s was a massive change in our electoral system. So we don't have a constituency-based system. We have a party-less proportional representation system. And so there's no link. Representatives are not held accountable by particular constituencies as regards the needs and interests of the citizenry within those constituencies. So any suggestion or any remark or argument about reviewing or revising or changing our system from a constitutional to a parliamentary system would, I think, have to go hand in hand with a change in our electoral system.
Professor Lawerence Hamilton, thank you so much. Professor in Political Theory at Wits University. Very interesting conversation to have. A lot more to talk about there, I think. In a moment.